far as I am aware, Mr. Lotterby, this is the first prosecution of a touring play for obscenity, or indeed of any play at all, under the Theatres Act 1968.
That is so, my lord.
Yes, I thought it was. Thank you. Very well, Mr. Lotterby, would you begin?
My lord. Members of the jury, according to the Theatres Act 1968, a play should be deemed obscene if taken as a whole its effect is such as to tend to deprave and corrupt those persons who are likely to see it. Now, from the 21st to the 23rd of April last, a play called Public Lives was presented at the Fulchester Palace Theatre by the defendant Alexander Pastor, a theatrical manager, and directed by Jeremy Williams, who is his co-defendant. Now, it is the prosecution's case that this play was obscene within the meaning of the Act. My lord, I produce a script of the version of the play performed on the 23rd of April, the night to which this charge relates, and I suggest that this might be the appropriate time for the jury to read it.
What, you're suggesting that we now adjourn while that is done?
Yes, my lord.
My lord, on a point of law, in the case of a trial of a theatrical entertainment, it isn't sufficient evidence for the juror simply to read a script.
Mr. Parsons, the Act does not specify what is or what is not sufficient evidence, but the prosecution could rest its case entirely on the script.
With respect, my lord, no. The moral and emotional effect of a theatrical production can only be judged in the atmosphere of a complete performance in the theatre.
Yes, but Mr. Parsons, until the passing of this Act, the sole basis upon which a play could be judged was the script.
Yes, my lord, and the Lord Chamberlain's office gave its judgment before a performance could be given. Now, this whole form of censorship caused much distress to actors and artists throughout the profession, and in consequence deprived the public of much work of artistic merit. It was because of this that the 1968 Act was passed. I would draw your lordship's attention to Section 1 of the Act, abolition of censorship of the theatre.
Yes, but nevertheless, the establishment of a system of post facto judgment, that is to say, a system of being wise after the event rather than before it, does not mean that a script is not of assistance when judging a play. I am, of course, referring to a script which has all the stage directions in it as the Act prescribes. And there is no indication in the Act that the jury should be subjected to a full performance of the play. And surely, Mr. Parsons, that is impracticable. I mean, the production was stopped by the police some 3 months ago, was it not?
Well, that is correct, my lord, on April 23rd.
And the production includes how many people?
Well, according to my information, my lord, there were 6 actors, an orchestra of 8 musicians, plus the director and a stage staff of 9. That is, of course, not including the staff of the Palace Theatre, who were involved with the production during its time there.
So that is upwards of 24 people to be reassembled, some of them scattered all over the country, and possibly in other work.
That is correct, my lord.
And since the play has not been performed for 3 months, I presume some sort of rehearsal will be necessary.
Yes, my lord.
How much?
Well, I'm no expert on the subject, my lord, but I should have imagined something in the nature of 2 weeks would be customary.
2 weeks?
Yes, my lord.
Mr. Parsons, even you surely must agree that to subpoena 24 people from their present occupation for a period of up to 2 weeks to give one performance for 15 people is, to say the least of it, an uneconomic venture. I cannot even imagine the Arts Council having much sympathy with that proposition.
Nevertheless, my lord, I do feel that in this case, above all, justice must be seen to be done. Now, it is my understanding that when the 1968 Act was passed, it was the intention to bring control of theatre performances into line with that of television productions and films. Now, in the case of television, the decision as to whether a programme may be shown is made by either the BBC or the Independent Broadcasting Authority after the programme has been made. Similarly, the British Board of Film Censors sees a film when it has been completed and makes its decision then, not on the basis of a script. I'm sorry to have to pursue this argument so rigorously, my lord, but it does seem necessary, as this is, by its very nature, a test case.
Yes, well, Mr. Parsons, even if there are reasons for saying that the jury should see this allegedly offensive material, I think it should be within the precincts of this court.
Well, with respect, my lord, that would be entirely lacking in the trappings and atmosphere of a theatre. The play in question requires many properties and scene changes, not to mention costume changes. And I would also point out that certain acts performed on a stage a certain distance from an audience, under carefully controlled lighting, might seem less offensive than in a room such as this. I suggest that the jury sees the play in a theatre with a full theatre audience, the context in which it would normally be seen by the public.
Whether the play would normally be seen in the context of a full house is, I suggest, Mr. Parsons, open to question. However, considering the allegedly offensive material and the publicity that it has received, perhaps you could be right. However, I clearly cannot allow it to be seen by members of the public, since it is at present sub judice. If Mr. Lotterby has no objection, yes, I am prepared to allow it to be shown in the setting of the theatre for which it was intended, if that can be arranged.
Thank you, my Lord.
My Lord, for all my learned friend's eloquent argument, I simply cannot see how a performance given by a group of actors subpoenaed by this court can possibly resemble the original article. Oh, they'll all know the purpose of the performance, and they'll obviously try to do their best to modify their actions accordingly. Television or a film performance, once recorded, is immutable, but a theatrical performance can be altered radically, especially if extra rehearsal is to be allowed, and this is to be conducted by one of the accused.
What do you say to that, Mr. Parsons?
Well, with respect to my learned friend, my Lord, no doubt prosecution witnesses are going to refer to certain actions in the play. Now, the only way for the defence to discuss whether these actions took place or what effect they had is to demonstrate them, and clearly the defence can't do this in the confines of a witness box.
I'd like to refer your lordship to the decision in the Crown v. Quinn and Bloom, 1962, when the Court of Criminal Appeal ruled that the reconstruction of an entire scene brought into existence for the purpose of constituting evidence could never be admissible.
Yes, well, I hear what you both say, and I am inclined to think that a theatre performance might help us in this matter. I think I may distinguish Crown versus Quinn and Bloom in that that was concerned with a play without a script. In other words, a striptease act performed in an alleged disorderly house. But I must make it clear to the jury that it is the performance of April the 23rd upon which you will be asked to pass judgment, and the performance that you will view can therefore act only as a guide. But, of course, that performance must follow the original as closely as possible. Do you have detailed written record of that performance of April the 23rd, Mr. Parsons?
Yes, my Lord, I do have the script of the Deputy Stage Manager, what is known as the prompt copy.
Will you place it in evidence?
Yes, my Lord.
And will either of you be calling witnesses who were present at that performance on April the 23rd?
Yes, my Lord.
Yes, my Lord.
Then I think it advisable that they should also attend the performance. Very well, we shall now adjourn until the performance can be viewed, and I must say that I look forward to it with some trepidation.
With respect, my Lord.
Yes, Mr. Parsons.
Is that entirely the proper observation for your lordship to make?
Possibly not, Mr. Parsons, but it expressed my feelings. The court will now adjourn.
My Lord.
Oh, what is it now, Mr. Parsons?
With your pardon, my Lord, I'm somewhat worried about costs. Now, it is not the fault of the defence that this trial could not be brought until 3 months after the production was closed down. Now, the cost of mounting a new production will be considerable. The payment of artists, the compensation to other managements who have lost these artists at short notice, the hiring of a theatre, the building of new...
Mr. Parsons, it is your eloquent pleading that has persuaded this court that it is legal to adopt this policy. Now, if the defendants are found to be guilty, then it is they who must bear the costs of the legal process. If they don't like that, we can easily dispense with this performance that you have persuaded me should take place.
Yes, my Lord, I do feel, however, that in this case...
Mr. Parsons, that is my ruling. The court will now adjourn.
All stand.